Welcome everyone for this Apéro du droit européen. It's a pleasure to welcome you virtually, at least, to this event, which will address a very interesting topic, which is improving access to protection and remedy to victims of human trafficking for labor exploitation. We'll be together for approximately an hour and a half, and we have a lot of interesting speakers and a lot of interesting discussions ahead of us. So as the chair, I won't take much time, but simply briefly recall the broad issue at stake and the interest of having such event. Trafficking in human beings is unfortunately a well-known phenomenon that has very diverse expression, and one of them is labor exploitation. Labor exploitation occurs in various contexts, in various types of environments, but shares the common characteristic that it represents a violation of the rights for those who suffer from it and fall for victims of it. And because of its impact on the rights of the persons and who are victims of it, many different instruments and initiatives have been developed at international, regional or national levels, including, for instance, through the adoption of general instruments addressing human trafficking as a whole, but also more specific instruments focusing on specific forms of exploitation. And we can think here, for instance, of the ILO Convention and Protocol on Forced Labor. The event today does not discuss this issue as a whole, but focuses on one specific aspect, which is the protection and the remedies that are offered to the victims of such forms of human trafficking. And here we are concretely discussing issues such as how a person who may be a victim of this form of exploitation is identified, and what are the rights, the measure that he or she may be entitled to as a potential victim of trafficking. And in European and international instruments, we find a certain number of provisions that grant these persons a certain number of rights, and they should normally be able to rely on these rights to have, for instance, access to legal, medical or social assistance. Within the EU, there are very diverse instruments, mostly directives, that contain such protection measures. We can think of the EU Anti-Trafficking Directive or the Directive 2004/81, which grants potentially residence permits to victims of trafficking collaborating with the proceedings. But we can also think of more general text, protecting victims' rights in general, providing the access to fair compensation, and also for the issue that interests us today, another directive, the Employer Sanction Directive, which focuses more specifically on employers who abuse of the precarity in which illegally migrants might find themselves, and then subject them to poor working conditions or poor living conditions. The interest of today's event is that despite the abundance of these instruments at international and regional levels, there might be very often a gap in their implementation. And it's not always easy to see how these protection measures are effectively enforced and implemented in the EU member states, which will be one of the aspects we'll discuss today. And we have excellent speakers to discuss this potential gap. We will start first with Irene Wintermayr and Dr. Amy Weatherburn. Mrs. Wintermayr works for the ILO Brussels office, and Amy Weatherburn is a postdoctoral researcher at the ULB. They recently published a study analyzing the mechanisms available in Belgium and in the Netherlands, and they will introduce us to the main findings and the conclusions they reached in their study. Then, to comment also on the analysis they carried, We'll have the pleasure to hear from the two following speakers, Mr. Knockaert and Eefje de Volder. Mr. Knockaert works for FAIRWORK Belgium, and he is holding the position of coordinator of his organization since 2010. And FAIRWORK Belgium is an organization that aims to improve the working conditions of workers who don't have a legal residence or who are in a precarious situation. And it will probably focus on the situation in Belgium. In contrast, Mrs. Eefje de Volder, who works as a human trafficking labor exploitation advisor for CoMensha, might more focus on the Netherlands and the situation in that country. CoMensha is indeed the independent national coordination center against human trafficking and offers expertise about the trafficking situation in the country, but also acts as the coordinator for the initial placement of victims in shelter or for providing them assistance. And at last but not least, as a discussant to all these very, I'm sure, interesting discussions, we'll have Mrs. Lilana Keith from PICUM. And PICUM is the platform for international cooperation for undocumented migrants, which is based in Brussels. And in her role as Senior Advocacy Officer on Labor Rights and Labor Migration, she will also be able to provide very much interesting insights on the situation. So this is the program for the next half an hour, broad half an hour, or the next hour, sorry, rather. I would invite you, if you have questions, to ask them in written in the chat box. And I will pick them afterwards for the Q&A part of the event that will take place at the very end. You're free to turn on your camera or keep it off, depending on your preferences. Without further ado, I'll just leave the floor to our first two speakers, Dr. Weatherburn and Mrs. Wintermayr.
Thank you very much. I will just share my screen. Can you see that in full screen? Just thumbs up. Okay, okay, brilliant. Well, thank you for joining us, everybody. We're extremely looking forward to providing a snapshot of our findings and then to hear from frontline professionals about the implications of our research on their daily business. But before we go to that, we will first set the scene by providing an introduction to the study that Chloe just mentioned. We will provide an overview of the remedy pathways that are available in theory, and then move to the challenges that are faced in accessing these pathways in practice. And then we'll share some of our conclusions and recommendations. So the research itself seeks to determine to what extent victims of trafficking for labour exploitation have effective access to protection and remedy in both countries, Belgium and the Netherlands. And through volunteering that Irene and I did at a human trafficking safe house in Brussels, we discovered that this isn't something that is always guaranteed for all victims, as there are those who, following the reflection recovery period, may not continue to receive victim support and assistance that human trafficking victims are entitled to. And this might be because there is a decision not to proceed with the prosecution, or the victim may be unable to cooperate with the criminal proceedings, which is a condition of continued support and assistance in both countries. In addition, we're also aware of the so-called dark figure of human trafficking, which means that many victims in fact go undetected and are never given the chance to engage with anti-trafficking actors who can provide assistance, advice and guidance on their rights. And for this reason, we wanted to also go beyond what is available in criminal trafficking proceedings and also identify the pathways for protection and remedy in civil, administrative and labour law, and to see what extent they're used in practice and indeed if at all. And we did this by conducting two phases to our research. The first was desk research that looked at existing reports and literature, and then interviews with anti-trafficking professionals in both countries. The interviews were completed in early 2020, and we did follow up later on in that year in writing to gauge the impact that COVID-19 had had, or to get an initial feeling for the impact. So the first remedy pathway is through criminal proceedings, and the study revealed that really the most viable route for human trafficking victims to access protection and remedy is through the anti-trafficking procedures, and of course where prosecutions are successful. This finding is obviously positive for those who are identified as victims of trafficking, because they will be granted access to shelter, financial assistance, psychosocial assistance, and for migrants with an irregular status, they will also be granted a residence permit. However, we do need to note that the number of overall successful prosecutions is quite low, and especially for human trafficking for the purpose of labour exploitation, when we compare it to the number of victims that are identified. For example, across Europe, the European Commission reported for 2017 and 2018 that there were just over 14,000 victims registered, compared to just over 6,000 prosecutions and just under 2,500 convictions. One issue that exacerbates the difficulty in securing a successful human trafficking prosecution is the high evidentiary threshold of the offence and the difficulty in ensuring sufficient objective evidence. And it's for this reason that prosecutors may decide to pursue a prosecution for non-trafficking offences such as fraud, sexual offences, social penal offences in Belgium, and perhaps also immigration or drug-related offences. Of course, the issue with such an approach is that the victim will no longer be recognised as a victim of human trafficking, and the support and assistance that they receive would be withdrawn. Civil proceedings are also an option for victims of labour exploitation, and in particular, a worker can make a complaint to the Labour Inspectorate, either of their own accord or with the assistance of a third-party organisation. The advantage of this is that the complaint is confidential, which means that irregular workers do not have to fear being reported to immigration authorities, which may well lead to their being deported. Similarly, a worker could initiate judicial proceedings to claim compensation for their unpaid wages through labour or civil courts. Compensation mechanisms are also available. Victims of violent crime are entitled to compensation, and fortunately we are seeing an increased recognition of the eligibility of victims of labour exploitation, even if the specific circumstances of their exploitation does not involve acts or threats of physical violence. Workplace accident funds provide indemnity for those who've suffered an injury in the workplace, and where a worker goes bankrupt, workers can claim their unpaid wages or social security contributions through insolvency funds. Alternative mechanisms were also identified in the study, and the first is the informal recuperation of unpaid wages, where trade unions or support organisations may contact the employer and request that they pay the missing wages. The crucial thing here is that the request for payment of wages is often based on the amount that had been agreed by the employer and the worker, and therefore does not always abide by national minimum wage legislation or the minimum wage established by collective agreements, bargaining agreements. Nevertheless, this mechanism is preferred in cases where the worker needs the money quickly and is not able to await for the outcome of lengthy proceedings. Another mechanism is sectoral compliance initiatives. For instance, in the Netherlands, a temporary agency workers foundation not only negotiates collective bargaining agreements, but also conducts inspections, has a reporting mechanism, and will launch judicial proceedings for violations of collective labour agreements. I'll now briefly touch upon three challenges that emerge when it comes to accessing these pathways, remedy pathways in practice, and these will be further discussed by our subsequent speakers. First of all, in the context of human trafficking criminal proceedings, there is a condition that any support and assistance is subject to the victim agreeing to cooperate with the criminal proceedings, as the high evidentiary threshold means that the testimony of the victim is often crucial to the prosecution. In Belgium, the cooperation requirement is applied in a very light manner, with anti-trafficking actors ensuring that as much as possible the victim's initial statement is used as evidence in chief, and subsequent requests for interviews are kept to a minimum. Second, in cases where a criminal prosecution has been successful, it can be difficult to physically obtain the compensation awarded by the courts, because in the meantime, the perpetrator may have gone bankrupt, offshored their bank accounts, or made their assets simply disappear. In the Netherlands, this issue is overcome by the use of an advance payment option, whereby if after 8 months the perpetrator has not paid the compensation, the state will advance the money to the victim and then launch proceedings to claim the money back from the perpetrator. The third challenge is that non-criminal proceedings and pathways are often extremely complex to access and navigate. And for instance, civil proceedings place the burden of proof on the worker. They can be extremely lengthy, costly, and there is a great uncertainty as to whether or not the outcome will be successful. Another obstacle, for example, in the Netherlands, following the employer's insolvency, claims to access state benefit must be made 1 week after the worker should have received his pay. And so it's for this reason that the assistance and guidance of civil society support organisations and trade unions is vital, as they have significant institutional knowledge of the eligibility criteria of these pathways, and they know when they need to act in haste. An example of this assistance in Belgium comes from the CSC-ACV trade union, who provided help to an irregular worker who had been a handyman in a gym in Brussels, who had also stayed overnight on the premises. So he not only lived, but he also was accommodated at the workplace. He was not paid the wages that he had been agreed, and after requesting that he be paid, he was fired. The employer went bankrupt, and when seeking compensation through the curator, the claimant's request for payment of wages on the basis of full-time employment was challenged by the curator. With the assistance of the trade union and MIRIA, the Federal Migration Centre in Belgium, the case was heard by the Brussels Employment Tribunal, who held that the working relationship was established despite the undocumented status of the worker and the absence of a written contract of employment. And as a result, he was entitled to compensation for unpaid wages, severance, and unfair dismissal. So I'll hand you over now to my colleague, who will present some of our conclusions and recommendations.
Thanks, Amy. So, yeah, I'm picking up on the conclusions and recommendations. So basically, we have a couple of recommendations that we've tried to group into 3 main headings. So first, making existing avenues for protection and remedy for human trafficking victims more effective. Second, enabling effective complaint and compensation mechanisms for potential victims. And third, tightening labor market governance and better enforcement of labor laws. So let me start with the first one. Next slide. So basically, under making existing avenues for protection and remedy more effective in practice. So we have a number of recommendations. I won't be able to go through all of them, so let me concentrate on the following. So the first one is in line with international standards to decouple support and assistance from cooperation in criminal proceedings. And if this is not possible in the short or medium term, then at least to keep it as light as possible on the victim. And Amy has already well explained that while there is this cooperation condition in both countries, the way it seems to be implemented is very different. A second point is to improve mechanisms to ensure effective compensation is received. Again, Amy has already referred to the advance payment option in the Netherlands, whereby if a victim is awarded compensation, at some point the state will step in and advance this compensation if the perpetrator doesn't pay. There's also reflection needed on group cases. So if multiple victims of trafficking are identified, which is often the case in labor exploitation, not all of them will be included on the indictment, and therefore, so part of those people will receive or will have a chance to receive compensation, and others won't. So how can those people that are left out, also for procedural reasons, to keep the indictment shorter, how can they also receive compensation? A third conclusion is tackling the high threshold to prosecution of human trafficking cases and ensuring comprehensive information gathering at the detection stage. So in both countries, when we talk to the practitioners, they perceive the threshold for to launch criminal proceedings for human trafficking as high, and there seems to be also cases where, because of that, because it's so hard to prove, the prosecutor will then go for lower level other offenses. And as Amy has also mentioned, this has detrimental effects upon victims' access to protection and remedy, as they will lose their victim status and what they're entitled to. And therefore, it's very important that the evidence gathering, so when the victims are detected at this stage already, as much possible as evidence as much as possible is gathered, because only if it has a good start, basically a good case can be built. So in our report, we look, for instance, at the report of the labor inspector. So when labor inspectors come across potential victims at the workplace, we make the case that they should really include detailed information on the living, the working, and potentially also the living conditions of the workers, the way that which they have found them, and also to include the contact details of those workers, because that is also a problem that sometimes if their contact with the workers move on, they can no longer be reached, and a case cannot really be built. And particularly in the Netherlands, there seem to be only very few cases of trafficking on labor exploitation that go to, for which proceedings are launched, that go to court, and there's a need to look further into this. So the Dutch National Rapporteur actually earlier this year published a report where he suggests that there's a lack of legal clarity on actually what trafficking for the purpose of labor exploitation means under Dutch law, and an absence of case law. So there's a need to develop this and to promote a common understanding, and that may require also investing in training of prosecutors and judges, and to kind of expand a common understanding, and potentially also exchange with other countries that may have more cases. Then we also suggest to increase focus and increase on detection of victims, because there's a strong suspicion that most cases of human trafficking go undetected. So that requires to continue a training for frontline actors, because actually it hinges on their capacity to spot signs of trafficking, whether or not maybe a person will be detected. And then it also means to ensure that they have adequate resources to some police, prosecutors, labor inspectors to actually investigate those cases, because they tend to be quite time and resource intensive. Next slide. So, and then as Amy has mentioned, we also go beyond what is available to identified human trafficking victims. And there we see a need to enable more effective complaint mechanisms and compensation mechanisms for potential victims. So those victims who may not have been detected, or who may have been referred in the national referral mechanisms, but then for whatever reason they have dropped out. Because at this moment, if you are not recognized as a victim of trafficking, essentially there's no formal support to help victims to lodge their complaints or to launch proceedings. And there's also a very high risk on the worker, because if a worker decides to complain against their employer, he or she may lose his job, and then his income, potentially his or her accommodation. And if the worker has been in a irregular situation, then and that even augments the precarious situation. So it's a very high risk actually on the worker to file a complaint, even though there are mechanisms available. So there should be a reflection on how such workers can be better supported. Can they be formally referred to organizations like FAIRWORK Belgium or FAIRWORK the Netherlands? And there's a need for those organizations then also to have the capacity and the resources to deal with the cases. And in cases where it's about exploited persons in an irregular situation, can they not get a temporary residence permit, at least for the duration of national proceedings, if they decide to launch them, or for the duration of complaints? And there would be actually, in theory, this possibility under the Employers' Sanctions Directive that allows for workers that have been particularly exploited to actually be granted a temporary residence permit. We also think that there should be a focus on replication of mechanisms that have been proven, or that where you have indications that this can facilitate effective access to remedy. So in our report, we look at the on-the-spot payments. In Belgium, the inspectors of the social legislation inspectorate, they have the power when they do conduct inspections, and on the work floor, they meet workers in exploitative situations that have not been paid, under certain conditions, to request the employer to pay the wages on the spot, and they can make use of a presumption of a 3-month employment relationship. So if the employer cannot prove otherwise, and there are indication that this person may have been working there for a while, they can assume 3 months. In the Netherlands, for instance, you also have labor inspectors have the power to fine employers for underpayment or non-payment of wages, and they can impose a fine until the employer pays. But this is also not something that apparently is being made use of a lot. And then in Belgium, there have been some very practical solutions found for situations, for instance, where workers have had workplace accidents, have been returned to their country, and help them to continue to claim invalidity benefits. And Jan may be able to say more about it, but it seems these mechanisms are very informal and could perhaps benefit from being more formalized. And then also, it could be useful to make the most of sentences against the employer. So for instance, in Belgium, if a prosecutor decides to bring criminal charges against an employer, to include the charge of non-payment of wages on the indictment, because then the worker could claim his or her back wages through that judgment and not having to launch separate civil proceedings once those proceedings have ended. And then in both countries, prosecutors, for instance, and judges and also labor inspectors, they should make use more of this presumption of an employment relationship. So if it's not clear how long a person has been employed in the Netherlands, there's a possibility to assume 6 months of an employment relationship if there's no proof to the contrary, and in Belgium 3 months. Yeah, and then as a last point here is it's important to strengthen civil society support organizations and trade unions. So what came out very clear in our research is that exploited workers will very rarely on their own lodge proceedings or lodge a complaint, and they seem to rely very strongly on the advice and guidance that civil society support organizations such as the two FAIRWORKs in Belgium and the Netherlands, but also trade unions have. So there's a need to strengthen their capacity and resources. And for Belgium, we also put in the report that they should become legally mandated as a designated third party that can lodge complaints on behalf of workers. Next slide, please. That brings me to my last point, which is tightening labor market governance and ensuring better enforcement of labor law. So basically here we take a step back from looking at how can we help individuals claim better compensation and try to look more at structural issues that may facilitate exploitations. So here we suggest that it would be very important to better enforce existing labor laws and collective agreements to ensure that the authorities responsible for that have the capacity to do that. And it includes also things like effectively addressing misclassification of who is a self-employed, who is a worker across EU borders, impose dissuasive sanctions on employers, and perhaps also improve laws and enforcement related to temporary work agencies. And as a last point, what we also wanted to have people reflect on is, Amy has mentioned it, that it's very important for workers to get their back wages, but that they are hesitant to do so if they have to engage in lengthy formal proceedings with an uncertain outcome. So whether wouldn't there be a way to use parts of administrative fines that are imposed on employers for violating working conditions that the worker has had to suffer, to use part of that fine to actually materially benefit workers in a more direct manner? They could still lodge other proceedings, but at least it would be a more straightforward way of getting them part of or what they are owed. Yeah, that brings me to the end. Thank you very much.
Thank you, Irene and Amy, for summarizing in a bit less than 20 minutes the amount of work you had conducted. I saw a question on the chat, and for those in the audience who joined a bit later, feel free to ask your question in written. We'll answer them as in bulk at the end of the discussions. And so, without further ado, I now pass the floor to Jan Knockaert from FAIRWORK Belgium.
Thank you very much. Thank you for the invitation and for the research, because it was very interesting to see it written on paper in the research. I have been asked to focus on a few aspects, so that's what I'll do. As in the research is stated and is in our experience, the support of an organization for an undocumented migrant who wants to file a complaint is crucial. First of all, we see that going to labor inspections themselves, the threshold is just too high. You're undocumented, you're not sure about your resident status, then go to an official service like the labor inspections is just a step too far, because they think that will have impact on their resident stay. So the role that we can play through our social media, through our website, is to first of all inform them on the fact that they do have labor rights, which is a first hurdle to take because lots of them are not aware of it. But secondly, also to really inform them about the fact that there is no impact. And we can see that this is really crucial. It often happens that you have to have 1 or 2 discussions before they are ready to file a complaint, to really assure them that there will be no impact on their residence stay if they file a complaint themselves. Then again, how do you structure a complaint? What is the information that has to be in the complaints so that labor inspection will pick it up and go further with the complaint? What kind of proof do you have to add? All this information is very hard to, if you go with no information to the labor inspection, very often they will not be motivated or have just too much work to have the capacity to assist this worker to add information to his complaints to go further. So also there you see that civil society can play an important role in assisting the worker to file a complaint that will give the labor inspection enough information to go deeper into the case and start a real research. Another aspect, for example, is if the worker decides or is obliged to turn back to his country of origin, the fact that we keep in contact with them can assist them. We have a few cases where the migrant worker has been deported by the government, but through the social media we're still in contact with them, and we have successfully ended cases where they did get compensation at the end of the case. And we were able to send the money to them even when they were in their country of origin. So also that is an aspect that's very important and a very important role that we can play. Of course, it's always a lot easier if the person is still here, also for providing proof. And if the employer states something, that you have the worker present so he can contradict or add information on what the employer has shared. Another aspect is, as has been discussed already, or mentioned already, proceedings can be very, very lengthy. Certainly in Belgium, our case that takes now, the longest case we have until now took us 13 years from the moment that the worker came to us until the moment we had a positive result, but 13 years. And that was a case of a labor accident from somebody who ended up in a wheelchair because of the labor accident. You can imagine if you don't have the support of anybody at that moment, you will just not keep going. And in this case, we were lucky that the undocumented migrant got the documents. This would not have happened in the current system. So at that time, you need somebody to inform them and also to explain them that it's a long procedure and that it's normal that it takes that's much time. It should never be normal that it takes such time, but sadly in Belgium that's very often the case. We do have to explain when the worker comes that it will probably, if you have to go to take the whole proceeding, it can easily take 1 to 2 years before, certainly if it's in Brussels, before you have a definitive court ruling. And actually that's fast, 2 years in Brussels. So all this information is important to mention and also to assist them. And very often you are the buffer between the proceedings, the translator from what the migrant worker says, and then to translate into the language that the labor prosecutor or court speaks. But also to explain to them, yes, it's very strange, it's completely illogic that it takes 2 years, but that's how it works. So very often we are the buffer for a lot of frustration there, and still we can support them to go on. 2 other aspects that I want to focus on, or I've been asked to focus on, is, for example, the labor accident fund. So if you have labor accidents in Belgium and you're a non-documented worker, the employer still should have an insurance, but of course this type of workers, employers very often doesn't have a labor insurance. So what happens is, in Belgium you have the system of labor accident fund that will intervene if the employer doesn't have a labor accident insurance. They really should find shorter words for this, these things. What happens is, in Belgium law, all the medical costs should be compensated. All the days that you can't work due of the labor accident should be compensated. And if you have a labor accident in which your capacity to work is permanently reduced, for normally you're able to work for 100%, but after the accident, you're, for example, only able to work for 80%, well, this 20 other percentage will be paid to you by this labor insurance, labor accident fund, until for the rest of your life. And that's, if you're undocumented or documented, that doesn't make any difference. Everybody can apply if, of course, you have a court ruling or a decision that this applies for you. So we have cases of people living in Ukraine, who had labor accident in Belgium, but each year receive 10,000 euros of compensation for the labor accident that they had when they were working in Belgium. And we have different cases of undocumented migrants still being undocumented in Belgium that receive each year of each month, depends on the percentage of labor incapacity that each month receive, even if they're undocumented, an amount from the compensation fund. It's also for the widow or children of a deadly labor accident. I hope we won't need it for the case in Antwerp, but also there, this compensation fund works. A similar fund is the solvency fund. So if the company of the undocumented migrant worker goes bankrupt, even there you can file for compensation. You're going to have to prove, of course, that you were working for this firm. But also there, the 3 months that was mentioned, that comes from the sanction directive, is we use. And there is a platform, a maximum that you can get from this solvency fund, which is around the 3 months threshold of Belgian minimum wage. So in theory, for each company that goes bankrupt, we would be able to get the compensation from 3 months salary, which is sometimes not enough in comparisons of all the period that they work there, but it's still something that we can achieve. And actually, sometimes it's a lot more easier to work through this system than that the company stays in existence and that we have to prosecute by the labor court or the labor authorities to get compensation. So sometimes we're very happy that the employer goes bankrupt because it's easier. Of course, it depends. The case that Amy talked about showed that not all of them curators are agreeing with these issues. But now we always send this judgment in attachment. First time we send the proof, and suddenly everything goes a lot faster than it used to be. We have a lot of less explaining to do that this is valid and legal. So these are just a few aspects of everything that has been told. I can go into depths on lots of issues, but I think I'll give the floor to my colleague now, to Eefje.
Many thanks. After.
Yes, can I? Okay. Okay, wait a second. Well, thank you very much. I think it's, do you hear me well? Yeah, okay. So I think it's always wonderful to listen to our Belgian colleagues, because we can learn a lot from them actually in the Netherlands. But let me first congratulate ILO, but also Irene and Amy in particular for this report, because I think it's a job very well done. And it shows very well what good practices are, but also challenges in relation to this access to protection. And as indicated already, we must admit that in offering protection and remedies to victims of human trafficking for the purpose of labor exploitation, Belgium is actually performing better than the Netherlands is. And in seeking to improve the position of the victims of labor exploitation, we actually, as support organizations, together with the labor union, but also with FAIRWORK the Netherlands, we have used Belgium many times as a good example in order to seek improvement in our own systems. If we then look at the recommendations in this report, they could not have come at a more timely moment. And even at the point where the Netherlands is scoring well, we actually see that the recent practice shows that there is still a lot of work to be done. One of the promising practices that was mentioned is the fact that more money has been allocated actually for the labor inspectorate to intensify the combating of labor exploitation, which is always good because then there is more capacity. But this actually comes at a time where the Labor Inspectorate in its annual report has shown that in 2020, only one labor exploitation case has actually been transferred to the Public Prosecutor's Office, despite all these efforts in intensifying the Labor Inspectorate and also the detection of labor exploitation. And then the recommendation to actually tackle the threshold of human trafficking when seeking to successfully prosecute a case for human trafficking comes at a time that a recent appeal in a labor exploitation case, for those familiar with the Dutch situation, the PrimeChamp case, which actually led to an acquittal on human trafficking counts. And this has raised concern whether the threshold is now not even set higher as it was before to come to a successful conviction in the Netherlands for human trafficking. And now it becomes even more questionable than was already also mentioned in the report, whether the Netherlands is in the practical application of Article 273F of the Dutch Criminal Code, our human trafficking provision, is living up to its international obligations to criminalize in actually certain types of behavior. What is also interesting is that the report highlights the good practice actually of integral controls with multiple controlling stakeholders, the labor inspectorate, the municipality, and the police or alien police. But a recent case that we had in the province of Limburg, the municipality of Linne, actually has shown that despite all these increased efforts, all stakeholders involved in this integral control did not pick up on potential signals of labor exploitation. And as a result, the workers were already out of the picture by the time the investigative authorities were involved, and they even heard through the media, not even through their own colleagues. And also the contact details of the persons were not written down, also one of the recommendations of this ILO report actually. And to us, it really shows that there is still very much need to invest not only in integral controls, but even more so in the coordination and the communication between these parties, and that to ensure actually that situations of labor exploitation go undetected. And that this is really not so much a one-time investment, but that it really needs continuous attention in order to ensure that if you have a staff turnover, et cetera, that you do not lose this expertise. Another recommendation was really looking to ensure more safeguards for the vulnerable position of potential victims at the early detection stages. And this is really something that goes to the heart of us as support organization. And it indicated that it would be beneficial to actually permit potential victims to speak to a support organization before, or have representatives of such an organization present during the informative interview. And what we currently see in the Netherlands is like the informative interview is actually the moment that the victim speaks to the authorities, and they need to determine their potential victimhood and are actually in between their access to the reflection period and protection. And even though it has a very well, a great impact on the lives of the potential victims, what is decided in that moment. In the Netherlands, it's something that is laid down in policy and not in law. And this is actually something that has been questioned or by a judge in a recent Dutch court case, that actually the Netherlands is not living up to its obligations under European legislation, because it includes early identification and the access to protection in policy and not in law, and thereby not allowing for sufficient safeguards to be in place, including, for example, granting formal review and appeal, which is currently not the case and should be possible when it is in law. So you see that many of the recommendations even became more timely nowadays. And well, another recurrent challenge that is mentioned in the report remains the conditionality of protection after the reflection period on the corporations in the criminal proceedings. Yeah, partly due to the fact that there is this high threshold of human trafficking cases, but also the anticipation actually on the high threshold by labor inspectorates and public prosecutors. It's actually more likely that the criminal case will be discontinued than it actually will be successful or will continue at all. And this limited protection that can be awarded to victims in reality may actually prevent victims in other cases to speak up, because the protection that is awarded, the limited protection that is awarded, does not outweigh the risk involved of speaking up. So here it is actually quite interesting, because this actually can, or potentially already has, because we don't have that many cases anymore, even though there were already very small numbers, but the numbers are decreasing each year, that it actually can have detrimental consequences for the willingness of victims to participate in these criminal proceedings and thus to combat trafficking successfully. So it is interesting that this combining this protection with the criminal proceedings, something that we already we already don't like to begin with, is there for the sake of the criminal proceedings, but actually it has a negative impact on the same criminal proceedings it's supposed to safeguard, particularly because of this high threshold and the low chances of a successful criminal case, and thus also the limited protection that is awarded. There is mention made of the pilot that we have on the multidisciplinary the determination of victimhood, and this was very positively received, but not so much by our government. So it was a pilot, and they indicated that they didn't want to continue, and also have indicated recently that there are many things that are open to discussion, but not to have this pilot in a more permanent form, which could have been like a step towards more protection loose from this criminal proceedings. Well, on a positive note, because I cannot be negative only, what is indeed a good practice as reflected in the report is the compensation awarded in criminal proceedings. I think this is something that we can be very proud of in the Netherlands, that we have this advance payment option where if there is compensation awarded, that the government will step in if the perpetrator doesn't pay for it. So that's very positive. But what we see in labor exploitation cases is that for the compensation to be awarded, to be in line actually with the damages, that the good financial investigation by the labor inspectorate is key. And this is not always the case, and that has consequences on the amount of compensation that is finally awarded. And the differences are very. If you look at the various forms, particularly sexual exploitation, well, this is really, the differences are very high. And then finally, the challenge that was also mentioned is that we have this compensation that will be awarded finally, no matter whether the perpetrator pays, but if there are multiple victims, then not every victim can be on the indictment, or well, they can be, but it's a decision by the prosecutor to decide who has the strongest case, or which story provides most proof to build this strong case. And this means that there is actually no equal access to compensation for victims. So you can be in the same situation of exploitation, but the one person will be awarded compensation and you will be not. And this is, of course, something that you cannot explain if you are supporting a group of victims in practice. So despite all the good practices, there are still quite some challenges ahead, I would say. And I think this report has actually helped us again to carve out what is needed to prioritize actually, what is needed to actually ensure that we are able to combat the human trafficking for labor exploitation more effectively, and to ensure the access to compensation and protection for the victims. Thank you very much.
Thank you very much. I think now it's time to give the floor to Lilana Keith. Yeah, now I see you, perfect. So you have the floor and you're free to add anything to what has been said.
Thank you for the invitation. So as was mentioned at the beginning, PCOM is based in Brussels, but we're a network. So we have member organizations in 34 countries, 168 members, not 168 countries. So we look at the situation of undocumented workers across the whole region. And I'd say that first of all, the report and the findings that have been presented are very relevant across the region. In many countries, we see very similar challenges. Indeed, some of the good practices that have been highlighted are things that we point to. So we could even say that on certain fronts, the situation across the region is worse than what's been found in Belgium and the Netherlands on some points. Maybe it's also useful to explain from the outset that we really look at our members assess access to remedy and justice for undocumented workers for any kind of labor rights violation. And so we really see labor exploitation on a continuum and address labor exploitation from everyday underpayment of wages to more severe forms of exploitation, including human trafficking. And we really feel the need to take a labor rights approach and to address it holistically. And that's another reason why this report and the way that this report has looked at access to remedy also outside of the criminal law system is very useful and kind of chimes much more with some of the work that our members also do at looking at the different kinds of complaints mechanisms that can be available, both for victims of severe exploitation, but also taking labor rights violations much more broadly. So then, in terms of the criminal legal system, as has been described, we see very similar challenges. We see barriers for, particularly when workers have an irregular status, significant barriers to enter into the system. Engagement with law enforcement often will lead to undocumented people receiving an order to leave the territory. If it doesn't happen before they're identified and referred into appropriate referral mechanisms as potential victims, they might face it as the procedure goes on, when it's decided whether or not a case will be taken, or even if the temporary permit is only for a short period of time. We've currently just today publishing a blog on the implementation of the Employers' Sanctions Directive. The Fundamental Rights Agency has just published a report on it as well. And some of the data that there's been gathered through both of those reports and been published now is really looking at how these residence permits are really not being implemented in practice. They're not accessible, and when they are, they tend to be quite short term. Our member in the Czech Republic, for example, was also explaining how many of the victims of exploitation that they work with will receive an order to leave the territory immediately with an entry ban, meaning that even if they, they're not able to come back, even if they leave the country and get a new permit to enter the Czech Republic to work again. So people are really being penalized because of their irregular status, rather than being protected as victims within this system. And then in terms of the other kinds of complaints mechanisms, we look at the labour courts, the employment tribunal, the civil courts, as well as the labour inspection. They're similar to what was described for Belgium and the Netherlands. There is access to the labour courts. The majority of countries that we've looked at, we did a mapping of 15 EU member states that we published last year. 13 out of 15 of those EU member states would treat undocumented workers' claims equally. There is no systematic checking of people's status. The issue is, and then not really reporting, except for in Germany. That was the one country where we saw that there was a bit more of a risk of immigration enforcement in relation to if the court would become aware of an undocumented person status, that they might pass on that information for immigration enforcement. But of course, the challenges for taking a civil case to court are enormous. We've heard about the length of procedures, the issue of the burden of proof and the risk of having to pay the fees if you would lose the case, access to legal representation. So really quite immense practical barriers that remain, and no real protection for workers during those civil proceedings. So even if there's no direct communication between the court and immigration, people are really worried that their employer will denounce them and immigration will act and issue them an order to leave the territory. But the complaints mechanisms with labour inspection authorities have then been quite a big focus for us, as we see them as something that would be kind of a lot lower in terms of the practical barriers, in terms of not necessarily needing the same kind of legal representation, in terms of the inspection also participating and helping to gather certain evidence. But here the major issue is around the firewall and what labour inspectors do with information around undocumented worker status. So because of sanctions against employers for employing undocumented people, we found that in all member states that we've looked at, labour inspectors are being tasked with checking the validity of work permits of undocumented people, undocumented workers that come to them or that they detect on the work floor. But the diversity is in what happens with that information, if it is used just to impose sanctions on employers, or if it's also used for immigration enforcement purposes. And there we see in the majority of countries, there remains a risk that that information will be used for immigration enforcement, even if it's only being reported to police for sanctions, in terms of how then the police might use that information. So it's a complicated web of what's happening with people's information, their personal data, and how that personal data is being used, that we're trying to pull out and map in each country to build in the necessary firewalls and safeguards at each step, so that people wouldn't face immigration enforcement as a result of engaging with labour inspection authorities. So that's a bit the lay of the land in the countries that we've been looking at and the region as a whole. I think I can end there, and we can have a discussion if you would like more information about specific countries or examples. I'm happy to provide.
Thank you very much. I see that there is already a couple of questions, but for those in the audience, if you have some new questions, feel free to raise your hand, like in Zoom or in Teams. WebEx allows to do so. And so if you have questions that you would prefer to ask orally, please feel free to raise your hand and we'll give you the floor after the speakers had the chance to answer to this first round of questions. They are quite broad, and I think maybe all of the speakers might have elements of answers to give, maybe to the whole, to all the questions, or maybe to some of them. I will just read them loud for the sake of the recording, for those who watch the event later can understand what this is about. The questions were quite diverse. They address, for instance, whether the complaint to the Labour Inspectorate is effective and how so. And I'm wondering if among those who have worked on comparative analysis, whether you found insights about it, and whether there are divergences from one country to another. There are another question that is maybe more for those familiar with the Belgian framework, and how what I think it's Amy, you used the word of light implementation of the cooperation condition in your presentation, and I guess it's a desire to know more about what it entails. And then the two next questions are about the practices that might have been developed in relation to the informal recuperation of wages. And again, here, if you have any insights on Belgium, Netherlands, or other countries, you're most welcome to share them. And at last but not least, at least for this first round, whether there are specific recommendations or good practices if it's not just about one victim, but several, and maybe a group of victims itself that is involved. So these are a lot of questions, and maybe I will just give the floor back to the speakers, but starting in reverse. If Lilana, you want to start, and then we'll move on to Eefje, Jan, Irene, and Amy. If that's fine with you.
Yes, so I think the main question would have been how effective the complaints mechanisms in Belgium are compared to other countries. It's hard to say. I mean, we definitely hold up as a good example the current system with the labour inspection in Belgium. We don't have as many cases in any other country where undocumented workers are really filing complaints with the labour inspection. Now, that's a lot down to the work of FAIRWORK Belgium. But yes, in that sense, it's really a standout in terms of having that kind of regular cases being filed, undocumented workers being really supported through that process and actually getting outcomes, actually getting some recuperation of wages through the system. Other countries have more effective employment tribunal systems, probably, where they're actually being used much more. For example, in France, the trade union takes cases of undocumented workers' labour complaints to the tribunal regularly, and that is also very effective, and there's lots of judgments that rule in favour of workers and their compensation. But there's more of a predominance on using the employment tribunal than the labour inspection complaints mechanism. So it also depends a bit on the habits, I would say, and the practice of the support organisations in terms of really using certain mechanisms. And in France, there are quite a lot of safeguards as well as access to regularisation. So there's various elements that really help make that employment tribunal system much more useful and accessible. But it's a reason why we do really try and encourage and support the relevant support organisations across the region to be testing the grounds, and also trying to use the employment tribunal more as much as possible with all the challenges that we obviously recognise. And then maybe I'll let other people maybe comment on other points, but I can also share maybe about informal recuperation of wages afterwards, if after we've heard from the other colleagues.
Perfect, thank you. Eefje, if you want to answer to any of the questions that were raised. We don't, let me see, I'll try.
Yeah, no, it's my sound. Okay, in relation to the informal recuperation of wages, well, I do know that the labor union at times is trying, like in an informal way with a company, to actually get some compensation, because through the formal ways it is much more difficult. But this is not all. Yeah, it depends very much on the company, the potential damage it can have in the media, etc., whether this is successful or not. So it has been used, but yeah, I don't think it is like really an outstanding practice that always works. Specific recommendations and good practices when more victims are involved. Well, I think the problem here is that if you want to have a bit more like class actions, this is more in civil proceedings, and there it is again difficult to get the compensation award actually paid. So I think, and this is also what we have been discussing in the Netherlands when improving the system, so to say, because we have been discussing it in the past 2 years and not too much of an effect actually. But there we actually have also said, like, can't we use this example in order to actually have people at least be listed on the indictment in order for them to get more compensation. But well, this is not what the current system allows for. So it needs really drastic changes, and this is not something that is happening anytime soon. So I wish I could have given good recommendations, but we don't have them actually.
Okay, thank you. It's a bit sad to end on a pessimist note, but maybe Jan, with the work you do in Belgium, you have more optimist examples.
So it's always funny to hear we are the good example and so on, because me and my colleagues only complain about all the things that don't work with us. Yeah. I think there is also still a lot of work to be done in Belgium, to be honest. On the effectiveness of a labor complaint, well, maybe I have to explain a little bit more the logic that we use. Very often we will almost never immediately go to a civil case because of all the things that have been mentioned, but also for the collection of proof. What will always happen if we file a complaint with the labor inspection is that the employer will be heard by the labor inspection and his answer will officially be noted. And maybe labor inspection will talk to witnesses or whatever. So they will be collecting proof for us, actually. And we have cases that then at the end, they stop with labor inspection without success, or the labor prosecutor classifies it because it's just one case and it's a small amount. They're not really interested. But because of the declarations of the employer in the case of with the labor inspectorate or the labor prosecutor, we have enough proof to then risk to go to civil court to claim wages. So the strategy on using the labor inspector, the labor authority, the labor prosecutor is double. Is maybe if they can solve it, but maybe at the end of their proceeding we have more proof, which can help us to work further on. We had more and more successes with the integration of labor inspection on filing complaints. But it really depends of the employer, actually. If the employer doesn't agree with anything, doesn't want to... Actually, your labor inspection has a sort of mediation role that they can play. They can say, look, this is what you should have paid, pay it, you get a fine, and then it stops, we don't go to court. And we have seen that it works. In the past, we had a case where it was like over 15,000 euros that the worker received by this regularization of the work, nothing to do with the documents of the residence stay, but just with the work that was paid, social security and wage. So that works. So I would say more and more we have success, but still a lot of cases get stuck somewhere because of lack of proof, non-cooperation of the employer. For example, he never shows up to the invitation of the labor inspection. and the labor prosecutor does nothing with the case because it's just a little case with not a lot of information. So we don't have a percentage. We never really do that because we think it's good for mental health to not know what is the ratio of success and non-success. But I think now we are at a point that we actually can do it, and we will see that quite a percentage would be have some sort of positive result at the long term. It would not at all be 50% or something like that. It will be rather around, I don't know, certainly less than 50%. The informal recuperation, also that is something that, to be honest, I'm not a big fan of, because you warn the employer that the worker is going to do something, and if there is proof, it's going to disappear. If there is proof that you still could collect, it's going to be disappear, and he's going to prepare everything. So if a worker asks us anyway to negotiate, what we will do is call him by phone, not leave a message if it's an answering machine, and register the call so that we have his direct response on our questions. We will never work with the letter because you don't get a response, and the employer is aware. If you have a phone call, he can say things that we can use in the future for the proceedings. Are these calls successful? Rarely. More of the time it's just you just get insulted, but sometimes it has effects. The employer is afraid and will call the worker afterwards to just pay. And even we had workers that contacted us, mentioned their employer that they contacted us, and that was enough for the employer to pay what was due. So it does work, but also there I think it's a very, very small percentage, and it's about employers who are not used to using this kind of labor yet. Employers that exploit people all the time in this way very often tell me when I'm calling them, like, file a complaint. I'm not worried at all. So it's not really, they're not impressed by the fact that we're going to file a complaint very often. Yeah, I think that were the most the questions that stuck. Oh yeah, and about the Belgium system, the light implementation, that's more on human trafficking, is not really my specialty. I think Amy will be more adequate in answering that question.
Yeah, absolutely. So this this idea of a light touch, let's say, when it comes to the cooperation condition, is very much based on the fact that victims who have been identified, they're also assisted by one of the three specialised centres, either Payoku, Pagasa or Surya. And because of that assistance, they will be accompanied to any interviews that they may have with law enforcement or labour inspectors, whoever is dealing with the investigation. And the main issue then is that following those initial interviews, there will then be continued assistance through the specialised centres, where they have almost, if they're in their shelter house, they'll have daily contact with the victims, but even if they're not being provided with shelter, they'll still be there on a weekly basis with meetings for different forms of assistance. And so then subsequently, if there is any more requests for information or follow-up from anyone who's dealing with the investigation, actually they will go to the specialised centres, the workers there first, and then if it's possible to share any information based on what they know, then they'll do that, rather than requiring the victim to actually sit down once again and go through the whole situation and experience that they've had. Of course, if it's absolutely necessary, then they will do a further interview, but it's really about ensuring that there isn't any re-victimization and taking into account the potential trauma that victims have come through. So that close cooperation between the different actors is something that's really came through in our research, and that everybody knows each other really well. They're used to working with each other, and that they will have this information sharing mechanism if they can minimize the involvement of the victim.
Irene, do you want to add something maybe, or?
Yeah, but there's actually, for me now, I'm in a very comfortable position because there's not so much to add from my side. I mean, on the informal or the alternative mechanisms to recuperate wages, what the union said, when the union said we spoke to, that they sometimes use it, but it's also not, yeah, as Jana said, it's not the way that will for sure bring something. And what we didn't look further into, what was one answer was, I think in Belgium, that they said that sometimes the labor attaché in the embassies, that they have good results when they get involved, but that seems to depend then on the country. So that's all that I have to add.
I saw Lilana, you want to take the floor maybe?
Thanks. Yeah, I just wanted to, on the point of the informal recuperation, similar experience in other countries. But I have found that there is a bit more use by trade unions in some countries of these kinds of like throwing the weight of the trade union behind calling an employer and say, this is a trade union member. We are, taking this case, and kind of threatening the employer is used more often. And so we've, raised to them also the risks and challenges that Jan's described, but they do tend to try that more often, I'd say, from what they've told us, with mixed success, but it is a go-to tactic by some of the unions. And maybe just to clarify what I was saying also about the efficacy of the labour inspection system in Belgium, it is, of course, because there is this guarantee of a firewall, which is the big difference. So that's why that is really the focus of our work in the other countries, to get that established, because then in that case it would be much easier for trade unions and for NGOs supporting undocumented workers to say, okay, this is going to be a safe procedure for you, and we can't guarantee an outcome, and it might take a long time, but you have a chance of an outcome, rather than, a big risk of immigration enforcement.
Many thanks. I don't see any hands raised, so I might just abuse my privilege as the chair to ask a general question again to all the speakers, because what I was intrigued is, it was briefly mentioned when Amy and Irene, you presented your study, or Jan, you mentioned it as well, how the pandemic had an impact in either decreasing the number of new cases, because some sectors that are sector where you regularly have exploitative working situations were shut down during the pandemic. And I'm wondering whether in your work you have seen some effects now that we are getting out of at least hopefully getting out of the more serious restrictions. And whether they might not also be, but that's maybe more for those working in policy work, whether there might not be a shift in priorities for governments and administration now that there are increased vulnerability, not only among workers with an irregular status, but more generally, and whether there might not be a risk that the situation of migrant workers is, how to say, kind of set aside or receives less attention because of fear that other workers might also be in danger of being vulnerable to exploitative situation. I don't know who wants to start. I saw Eefje, you maybe, Jan, yeah, okay, yeah.
We at the beginning of, in the beginning of the first lockdown, we got a lot of distress calls, I would call them. People who were out of food, didn't have any income during a long lockdown, didn't have any access to food anymore, couldn't pay their rent anymore. Although there was an interdiction to throw people out of their housing, of course, for undocumented migrants, it was also valid, but people don't know it, and landlords don't care. Though people were kicked out and on the street without a job, without food, and without shelter. Also, first line organizations were also closed, so it was a very dire period for undocumented migrants. And you've seen, and luckily other first line organizations completely turned around their way of working to just deliver food and find direct solutions for undocumented migrants, while governments were completely absent. That was people who work for 20 years in the sector said there things happened that we haven't seen in all those years that we were working with undocumented migrants. That meant, of course, that that had two effects on the complaints. People who wouldn't complain otherwise did file a complaint because they, in the hope that they would at least get some money through this way. On the other hand, when we got out of lockdown and people could start working again, well, in this period with lockdown, people accepted labor conditions even more lower than they normally would accept because it was that or nothing. There was no alternative jobs. And we've seen when lockdown eased and some sectors opened again, that people came to us to complain, wanting to file a complaint, but very fast going to the conclusion that I will not find another job, so I will be without any income. So I will stay with this employer that exploits me, which I know they exploit me, but I just don't have any alternative because I will be without income. And for the moment, now that most sectors are back open, we see it. I don't know if it's linked with that, but we see for the moment, the last few weeks, that we have less cases that can. Sometimes you have such periods, and sometimes that are not linked at all. So I'm not sure if this is linked, but it could be that, for example, people are starting to find a job again, invest in the job after a very dire period, and accept the situation now, and probably in a month or two we'll have new cases in hotel, restaurants, cafe sector, for example, where they will come back to us with saying, I started working there. So that are for the COVID pandemic, the impact that we have seen, but probably there will be fallouts still to be seen in the future.
Thanks. I don't know who else wants to add anything. I don't know if Amy or Irene, you have something to say, because you mentioned that you did interviews also after the first lockdowns, and whether you saw an impact of it in your analysis.
Maybe I can say something. So we did have some follow-up conversations, and actually some of the people are also in the calls. So they are maybe in a better place. I mean, what we know from the Labor Inspectorate is that there were not so many inspections that that their normal organizations was, of course, also disrupted, and a lot more resources went to ensuring that COVID measures were complied with. So they were not carrying out the inspections in, let's say, high risk sectors for labor exploitation, and that had an impact. But maybe can I invite also, I see that FAIRWORK Netherlands is on the call, when if they want to take they're not a speaker, but they have a lot of experience also with being on the front line, and can also give some perhaps insights to the Dutch situation if they want. There's no obligation. I mean, I'm calling you out there. So yeah.
Yeah, well, I think that's me. I was not really expecting this invitation, but thank you, Irene. And please let me, because I think there's lots of rumor around me. But yeah, I think in the first place, we were really happy with this report because it really reflects our worries, and I think the things that we are advocating for, and the challenges that we see. I think actually Eefje summarized really well also all the worries that we see, and same for Lilana when it comes to the firewall. I think that's also an issue that improves rarely, I mean hardly, because we are talking so much with the Labor Inspectorate about this issue, and they are not changing much in my view. So I find that a tough issue. Well, regarding all the things that Jan said, I think from our side, we can say that we also learned a lot from FAIRWORK Belgium. I mean, lots of practices that Jan just explained, we are also applying now, such as making phone calls to the employer and recording them. And yeah, we face, of course, the same dilemmas, like should we go for the civil case, or should we try to put the employer a little bit under pressure and get the wage informally? I think the dilemmas are really similar, and also, yeah, the same for the what works and what does not work. Maybe in our case, in a little bit, there are fewer cases that did work, unfortunately. Yeah, I think I was just listening happily because yeah, I was. As I said, we were really happy with the report. I think it's very useful also for further discussions. And yeah, thank you so much for.
And I wanted to ask you also, because in the COVID question, because what was your impression then on the, sorry, on you know, how COVID impacted your assistance to victims of labor?
Yeah, well, actually, the target group that we are supporting is, on the one hand, lots of agency workers, European workers, and on the other hand, undocumented workers. So I think from both sides, the request for support increased very much. For the undocumented workers, the same applied as what Jan explained. So lots of people called us to say, I lost my job, I have nothing, I'm going to be thrown out of my house, what to do? And actually what made a change for us as well, because we saw this extreme stress among these people, we established a small, very modest emergency fund for like most vulnerable people without who lost their job and couldn't did want to improve their labor situation, but there was actually not much to do. And because we had that fund, that somehow also attracted, of course, more people. And very often we also saw that people that came in the first place just to say that they lost their job, actually when we talked to them more intensively, we actually got to know that before they were working already for a long time in a quite exploitative situation. And that was also interesting to see. And with several of these cases, we could also still start a case, or some also denounce their employer for exploitation. So in a way, I think people got more visible to us because they were more desperate, and that also brought more cases of exploitation to made it more visible. And on the other hand, the agency workers, I think in a very different way, they also were in bigger problems than usually, because they had all other kind of problems, indeed, like losing their work, but also having to continue to work despite the COVID measurements. So yeah, I think it just increased the request for support a lot, but it also brought more insights in cases, made it more visible for us.
Thank you very much. It was a good compliment and a very good answer on the spot. I don't know if you, Liliana or Amy, you want to add something still on this question, or any other issue that was raised during the discussions?
I think what is good to mention in the Netherlands, of course, due to COVID, there was also a lot of attention for the position of migrant workers. So that actually has resulted in more public outcry, and also a commission being established, and all kinds of recommendations that were adopted to improve actually the situation of labor migrants. Well, and there the focus is really on EU migrants more than undocumented migrants. And to actually decrease their dependency, and to make the role of recruitment agencies lesser, etc., etc. And this has been fully accepted, but the problem is now the implementation, also because our parliament is still needs to be set up. But this is again also what was mentioned, maybe a bit the fear that because now the situation changes again, that the pressure to actually arrange things is diminishing. So yeah, the fear is that we have all these good recommendations, they are politically accepted, but it will not result in any practical changes in the reality of the labor migrants. So that is quite unfortunate. So maybe for that, the lockdown should have lasted longer. I don't know, it's a joke.
Yeah, it's always difficult. It's always a question of momentum, and if the parliament takes longer to be established, I imagine it plays a role. Lilana, do you want to say a final word, or it's?
Yeah, I see that we're out of time, and there's a lot that could be said about COVID. So maybe I'll just mention very briefly to kind of end on a mixed, like slightly positive note. Is we did see that some policies that our members have been advocating for years and years and years that were blocked were suddenly pushed through in some cases. And we don't know, the fight now is to get those actually made structural and maintained. In some cases, it's already rolled back. In some cases, they are being prolonged, but they haven't been made structural changes. So there has been some positive developments related to the emergency situation that was created. So we're just trying to capitalize on those to really say, look, therefore it can be done. So let's just keep it now and not roll back again. But all the challenges, of course, that were described were also shared by our.
I guess it was just called for organizing another event in a couple of months to see whether some of these measures worked and were prolonged in time after the peak, so to say, of the crisis. I don't know if Amy or Irene, you want to add a few closing words, but otherwise we're gonna no. Okay, so I think then it would be just my role as the chair to thank you all for these very interesting discussions. I learned a lot, and I saw a comment in the chat from someone saying that again these discussions were very helpful to hear about the studies and the practical experiences. The recording of the event will be made available in a couple of days, and you'll be informed about it. But thanks again to all the speakers and the participants for these very engaging and interesting discussions. And I hope that at some point we'll be able to welcome you in person at the Center for European Law at the UAD. Would be our pleasure. So good evening to everyone, and